On the record, in the matter of the people of the state of Michigan versus Matthew Richard Torres, file number 23-00818, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Matthew Torres, who's not here.
Okay, where is Mr. Torres?
Apparently, Mr. Torres is at home.
Oh, why is that?
He has crippling anxiety, it seems, and he hasn't left his house in 7 days because of all this. So I've talked to him, I've told him what's gonna happen, and nothing I can do.
Okay, I'll issue a bench warrant. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for defense.
Thank you. Okay, on the record, in the matter of the people of the state of Michigan versus Norandi Limas, file number 23-00761. Where's Mr. Lee? Counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Lorraine Lemus.
Today's date and the time is set for jury trial. I did have a in chambers conversation with counsel. We have called in the jury. All the parties are here.
Yes, Your Honor.
Okay, are your witnesses are here?
Yes.
Okay, and so I've instructed my staff that due to the tight schedule that I need to run today, as soon as the jury gets here, they will be brought up. I can't go looking for either of you all today. They'll be brought up. We're gonna start voir dire immediately. Anything most likely 10:30 and beyond will be reset, okay?
Absolutely.
Okay, and so any preliminary matters before we adjourn until the jury gets here?
Nothing from the people, Your Honor.
Nothing for defense.
Okay, thank you. Make sure your meter's all paid up and all that stuff, so we don't have to look for you when it's time to start, okay? Yep, thank you. Thank you. On the record, in the matter of the people of, is Ramona Hunter?
Downstairs.
Okay. On the record, in the matter of the people of the state of Michigan versus Ramona Hunter, would you have witnesses here?
I have, Your Honor, I have called the hallway in the courtroom. I have not seen the complaining witnesses.
Okay, and I'm assuming, Mr. Lee, you did not speak to your client today, but he has no witnesses here. Are you gonna waive your client's appearance for a motion to dismiss?
I am, Your Honor.
Motion to dismiss is granted. You can advise your client that it's without prejudice. On the record, in the matter of the people of the state of Michigan versus Duana Cheyenne May, file number 23-02204, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Dewana May.
Okay, Ms. May, today's the date and the time that's set for final pretrial and domestic violence. Do we have complaining witness here?
Yes, we did.
Okay, what's there on offer?
Yes, there was, Your Honor. After speaking with defense counsel, the offer would be to plead to an added count 2 of disorderly person jostling, Your Honor.
Does your client want to?
My client will accept that offer, Your Honor.
Student advice of rights? Ma'am, do you want to accept the offer to plead guilty to an amended charge of disorderly jostling? Yes, Your Honor. Are you sure? I'll give you more time to think about it if that's what you want. You want more time or you want to plead guilty? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Yes, Your Honor. If you can put your hand down. Ma'am, disorderly jostling is a misdemeanor. Maximum penalty is 93 days in jail and or $500 in fines. You have the following rights that you would have to give up before you can plead guilty. One is the right to the presumption of innocence. So as you stand there right now, you're innocent, and you're innocent until the prosecution can prove you're guilty. You have the right to proceed to a jury trial in this matter. You have the right to require the prosecution to prove each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, question, or confront in court any of the witnesses that the prosecution intends to call against you. You have the right to call your own witnesses or present defenses at trial that you believe would help support you in defending this matter. And you have the right to remain silent at trial and not have silence be used against you. Do you understand all of those rights?
Yes, Your Honor.
You're willing to give each of those up to plead guilty to disorderly jostling?
Yes, Your Honor.
Anybody threatening you to get you to plead guilty?
No,
Any promises being made to you to get you to waive your rights and enter a guilty plea today?
no, Your Honor.
Are you currently on probation or on parole?
No.
You understand that a guilty plea could result in a conviction that you may need to report to your current employer, or you may need to put this conviction on a future job application.
Yes, Your Honor.
You also understand that a guilty plea can result in a conviction that may have impact on travel or immigration status you may be seeking. I'm sorry?
Yes, Your Honor.
Okay, and with that understanding, you still want to waive your rights?
Yes, Your Honor.
Okay, as to the amended charge of disorderly jostling, how do you plead?
Guilty, Your Honor.
Are you pleading guilty because you believe you're guilty? You have to say it so I can hear you.
Yes, Your Honor.
Okay, on the date or on or about June 22nd, 2023, were you in the area of 1119 North Walnut Street?
I'm sorry, what date was that?
It's June 22nd.
No.
Okay,
I have a date, June 23rd.
my complaint says June 22nd.
That is also incorrect.
My affidavit of probable cause says June 22nd.
The incident occurred on June.
Okay, but it's on or about, so that doesn't, it's not germane. We can amend the complaint. So you said it was June 23rd?
June 20th,
June-
Tuesday?
June 20th, were you in the area of 1119 North Walnut?
Yes.
Okay, that's in City of Lansing,
Yes.
Ingham County, State of Michigan.
Yes.
Tell me what you did that made you guilty of disorderly jostling.
I tried to leave.
You tried to leave where?
1119 North Walnut Street.
Why did you try to leave?
I had gotten grabbed by the back of my head and had my head shoved through a wall, so I had my children and gotten them to leave. I
Okay,
went
that's
to,
enough. We'll continue to trial. I can't accept your plea. You can't give me a factual basis to support that you're guilty of what they're asking you to plead guilty to, okay? You don't plead to charges and you don't accept pleas to resolve matters. That's not appropriate. You plead guilty because you believe you're guilty. You understand that? Okay, we'll continue to trial. You're all set for today, okay? It sounds like you have a defense to the charge. Okay, we'll make sure she continues or gets another copy of her trial date. On the record in the matter of the people of the state of Michigan versus Andrew Ryan Mick, file number 23-02231, council appearance.
Jeff Rodowitz on behalf of the people, Your Honor. Jacob Brown on behalf of Mr.
Okay, today was the date and the time set for final pre-trial on our assault and battery. Do we have complaining witnesses here?
Yes, we do, Your Honor.
Okay, was there an offer?
Yes, there was, Your Honor. That offer would be to plead to, or I should say, accept responsibility for a civil infraction, disturbing the peace civil infraction, Your Honor.
Does your client want to accept that?
Yes, Your Honor.
Okay, that's correct, sir.
Yes, ma'am.
Okay, your fine is $130. When can you make payment?
Yes,
When?
today.
Okay, we'll get you over to the criminal traffic window. You'll be all set. Do you have any questions for the court?
No, ma'am.
Okay, you're all set. I'm sorry.
There's another file needs to be arranged, Judge.
On the record in the matter of the people of the state of Michigan versus Andrew Ryan Mick, file number 23-02500, council appearance.
Morning, Your Honor. Assistant Public Defender Jacob Rowley on behalf of Mr. Mick for the purpose of this arraignment.
Okay, Mr. Mick, I have a file here with a misdemeanor complaint that alleges that on or about May 15, 2023, at the area of 117 Paris Ave, City of Lansing, Ingham County, State of Michigan, that you did allegedly contrary to law commit the act in count 1 of domestic violence. The allegation is that you did make an assault or assault and battery upon a Kylie Malusi, an individual with whom you had a dating relationship, and that this was done contrary to Michigan Compiled Law 750.812. Restitution may be ordered as this offense may have resulted in damage to another individual's property or physical injury or death to another individual. This is a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty?
Yes, ma'am.
Okay, you have the right to be represented by counsel. Mr. Raleigh is representing you for this arraignment only, but you have the right to make a request and have an attorney represent you at each stage of the prosecution, and you have the right to be represented by counsel if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office represent you at the expense of the public, and you are being represented by the public defender's office in your other matters, so the presumption is that you're likely still eligible to be represented in this matter. Do you understand that?
Yes, ma'am.
Did you want to request a representation?
Yes.
Okay. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or you stand mute. If you stand mute, this matter will proceed to a trial. You have the right to a jury trial. At the time of trial, you have the right to the presumption of innocence. So you're innocent until proven guilty. You understand that?
Yes.
You have the right to require the prosecution to prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You understand that?
Yes, ma'am.
Okay. And you have the right to remain silent at trial and not have silence be used against you. You have the right to confront in court, cross-examine, or question any other witnesses that the prosecution intends to call against you. You have the right to call your own witnesses or present evidence that you believe further defense to the charge of domestic violence at your trial. Do you understand that?
Yes, ma'am.
And do you have any questions about those rights?
No.
Currently scheduled for a pretrial conference before me on Monday, November 6th at 9:30 in the morning. We'll get you a copy of that notice, okay?
Thank you.
For the purposes of his arraignment, the court will enter a plea of not guilty on his behalf. We'll also set bond in the amount of $500 personal recognizance. Next time, and I'm talking about, I gotta arrange when I get $500 personal recognizance and a no contact order in place for the protection of Kylie Malusi. You're not to be within 1,500 feet of wherever she is. Do you understand that?
Yes, ma'am.
You're not to have contact directly or indirectly with her. Do you understand that?
Yes, ma'am.
You're not to use, purchase, or possess drugs or alcohol while out on bond. You're not to engage in any assaultive or threatening behavior. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. You need to come to all of your court dates. You have any questions?
No, ma'am.
Okay, any additional matters on this record?
No, Your Honor.
You can have a seat. We'll get you a copy of your notice to appear. Okay, on the record in the matter of the people of the state of Michigan versus Anthony Devon Price. This is in file number 22-02655, council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Jacob Rowley on behalf of Mr. Price.
Okay. Mr. Price here?
He's not here, Your Honor.
Okay, have you been in contact with him?
Not communication. I do not have good contact.
Okay, we'll issue a bench warrant. And bond forfeiture. Off the record in that matter. On the record in the matter of the people, the state of Michigan versus Michelle Lynn Van Drunen. File number 23-02121, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Rowley on behalf of Ms. Van Buren, who is present.
Okay, how are you, Mr. Benjamin?
I'm good, how are you?
I'm very good. Today was the date and the time set for a final pretrial on one count of domestic violence. Is the witness here?
He is not, Your Honor.
At dispense with motion for dismissal.
A motion to dismiss is granted. We'll get you a copy of the dismissal in just a moment. It's without prejudice. That simply means that the prosecution does have the right to reissue the charge against you within the statutory timeframe if the witness changes his mind and wants to prosecute, okay?
Yes, no,
Do you have any questions?
no, ma'am.
Any additional matters?
Nothing from the people, Your Honor.
No, Your Honor.
Have a seat. We'll get you a copy of your dismissal, okay, ma'am?
Thank you.
You're welcome. On the record in the matter of the people of the state of Michigan versus Rayshawn Worthy, file number 23-02053, SM, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Rashawn Worthy.
Okay, today was the date and the time, Mr. Worthy, for a final pretrial on one count of domestic violence. We have a witness.
Do not, Your Honor.
This time the defense would like to make a motion to dismiss, Your Honor.
Motion to dismiss without prejudice is granted. Again, that means that the people have the right to reissue against you if the witness changes their mind and wants to prosecute, okay? But they have to do that within the statutory time period. Do you have any questions? Okay, we're gonna give you a copy of your dismissal in just a moment, okay? You're welcome. In the matter of the people of the state of Michigan versus Delvon Golden, file number 22-03537, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Rowley on behalf of Mr. Golden.
Okay, today was the date and the time that was set for a plea on an animal abandonment. Is Mr. Golden here? Is that Mr. Golden there?
Yes.
Okay, how are we proceeding?
Your Honor, I would appreciate the opportunity to speak to Mr. Golden. I didn't speak to him today.
Okay, give me a new plea date, please.
But look at the mom's getting it outside of the 40%. You go into the.
Added on October 30th at 9.
October 30th at 9. Mr. Golden, what's your phone number?
517-881-1601.
Okay, hang tight. Your attorney's gonna log in. He now has an accurate number for you. And then we'll see you at your next plea date, okay?
Okay.
Okay. On the record in the matter of the people of the state of Michigan versus Sergio Gonzalez, file number 23-01205, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
John Lee on behalf of Sergio Gonzalez, who's in the courtroom and standing.
How are you, Mr. Gonzalez? How are you, Mr. Gonzalez?
Good, how are you?
I'm doing well, thank you. Today's the date and the time set for a plea on assault and battery, and then I have a hearing set for a bond violation. How are we proceeding?
The offer on the assault and battery, Your Honor, was to plead guilty to a amended charge of disorderly jostling. Mr. Gonzalez is going to accept that charge.
To have an advice of rights? That's correct, sir. You want to plead guilty to disorderly jostling?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
You can put your hand down. Disorderly jostling is a misdemeanor. It's a maximum penalty. 93 days in jail and or $500 in fines. In order to accept that offer, you would need to give up your rights, and that means you're giving up your right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at a jury trial by proving each element of the charge being brought against you beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
Okay. You have the right to confront in court any witness that the prosecution intends to call against you. You have the right to call your own witnesses or present evidence that you believe further a defense to the charge being brought against you. You have the right to remain silent at trial and not have silence be used against you. You understand that?
Yes, Your Honor.
You willing to give up each of those rights today?
Yes, Your Honor.
Anybody threatening you to get you to give up those rights?
I'm sorry.
Anybody threatening you to get you give up those rights? He can't do that now because I'm talking to him.
No, ma'am.
Okay. Any promises being made to you in exchange for you entering a guilty plea to the amended charge?
No, ma'am.
Are you currently on probation or on parole?
Yeah.
Okay, with 30th Circuit Court?
Yeah.
Okay, and have you discussed with your attorney how this may impact your status on probation? You have not? Okay, reset plea date, please. October 30th at 9. Have a seat. That next time you'll be ready and you'll have gone over your rights before we accept the plea, okay? Mr. Raleigh, your client logged off, so you're gonna have to call him.
Thank you, Your Honor.
Thank you. Natalie Odd's not here yet, is she? Did we get Miss Van June in her Ollie? I don't think I signed in Ollie. There go. Everything else until 9:15. Jury instructions.
You have an attorney?
Oh, Raleigh, you said. Who you with? Lady? What's your name, man? Wheeler? Do you have an attorney?
I think he's gonna get on the Zoom. I'm not sure. I hired attorney.
Yeah, I mean, as soon as all the jurors are here, they're.
have to wait for the judge to sign your now, okay?
Okay.
So, just to let you know.
Yeah. I'll make sure phones are off, okay?
I just had to add more time to my meter real quick. I'm turning that right back off.
What's your name, ma'am?
Caroline Brandon.
Okay, you just have a seat.
Oh, yeah.
Good morning, sir. Can you unmute and tell me your name, please?
Samantha DeBourbon. Sorry about
And you
that.
are Samantha DeBourbon?
Yes.
Okay. Are you able to change your background, sir? Because the background you currently have is not appropriate for court.
Oh, I can switch to. I could definitely do that. I'm in my workshop. My apologies. My house has got dogs, so hold on just one moment. And let me grab my charging block. How about now?
That's better, sir. I'm just gonna keep you on mute for the time being, okay?
All right, cool.
On the record, in the matter of the people of the state of Michigan versus Caroline Brandon, file number 23-02414, council appearance.
Jeff Broadus on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Carol Brandon.
Today's date and the time set for a pre-trial. I have one count of abandoning cruelty of animals. How are we proceeding on this?
It was at this time, Your Honor, the people had made an offer for the defendant to plead to an added count 2 of abandoning cruelty to one animal with restitution. However, at this time, the people have not yet received the quotation from the Ingham County Animal Shelter. Ingham County Animal Control, my apologies. I had talks with Mr. Lee, so I will let him go further with that, Your Honor.
Counsel.
Yes, Your Honor, Ms. Brandon is prepared to plead guilty to one added count of abandoning cruelty to one animal. My understanding is that there is a killabrew for no upfront jail and that she will agree to pay restitution. However, this was supposed to be the time and place where restitution was supposed to be decided. Not sure what
You have a plea sheet? What's the penalty? We don't have a plea sheet or advice of rights, and we don't have restitution.
we do restitution.
Not at this time, Your Honor, and in the process.
Let's set it for a plea, please. October 30th at 9. October 30th at 9. Date for the plea. By then we should have restitution from Ingham County Animal Control. Any questions today, ma'am?
No, we do not.
Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing for the defense. Thank you.
Okay, you're all set. On the record in the matter of the people of the state of Michigan versus Samantha DeBourbon, file number 23-02526. Council appearance.
Jeff Broadus on behalf of the people, Your Honor.
On behalf of Samantha DeBourbon,
Is Samantha DeBourbon present?
she is on Zoom.
Yes.
Okay, today's the date and the time that's set for a pre-trial for dog at large. How are we proceeding?
At this time, Your Honor, after conversations with the defense, and I'm not sure why this is, but I have searched, at least on Friday, I had searched the prosecutor's system and I did not find a file in our system under that name. And in conversations with Mr. Lee, I don't believe the public defender has any of the discovery or a file by that name either, Your Honor. So at this time, I guess we would request an adjournment in order to figure out what's going on, and so we can both be properly prepared.
You have discovery by what name?
Samantha DeBourbon. The name I checked.
You have a picture of this, I mean, you do have a copy of the citation?
I don't even have that. in
We
my-
have it. So it's obvious, and the last name is spelled DEBOUR, B-O-N.
DEBOURBON.
Yes. We'll reset the pretrial.
I just searched our system, the prosecutor system again, Your Honor, and I have no file with that last name, so I will figure out.
November 6th at 9:30 is the new court date, okay? Okay, no, you unmute your device, please.
Yeah, absolutely.
Okay, do you have any questions?
Nope. I'm just kind of.
Okay, any additional matters for the record, counsel?
Nothing from the people, Your Honor.
Okay, we'll see you at your next court date, okay?
Excellent.
Thank
See you
you.
guys then.
On the record in the matter of the people of the state of Michigan versus Lyman Hunter, file number 23-02677. And that's Lyman Hunter the fourth. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Riley on behalf of Mr. Hunter.
Okay, Mr. Hunter, I believe I just saw you last week. Is that accurate? Okay, today's the date and time that's set for a pretrial on a malicious destruction of a building and a retail fraud, third degree. Is there an offer on this?
At this time, Your Honor, the offer on this, there is no specific offer to this case. Mr. Hunter, as you noted, Your Honor, has one other case currently before you and one case that is still in screening with the prosecutor's office. It is the people's intention to do a global resolution involving all three cases. I am in communication with the attorney, Mr. Palmer from the Public Defender's Office, as to what the offer would be, and I will as well loop in Mr. Rowley. The offer would potentially include dismissing this file with restitution on the felony file, Your Honor. And so with that, we would just ask for an adjournment of this until I believe this other matter is set sometime in, I can't remember the date, but it would be after the date set for the preliminary exam on the felony file.
The exam is set for December 6th. Okay, give me a date. December 18th at 9:30. Do you have any questions today, Mr. Hunter?
No, I don't think so.
Okay, any additional matters for the record today, counsel?
Nothing from the people, Your Honor.
You're all set for today. Thank you.
All right, have a great day.
You too. On the record in the matter of the people of the state of Michigan versus Samuel Joseph Parker, file number 23-02868. Appearance, please, counsel.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Riley on behalf of Mr. Parker.
Okay, Mr. Parker is present via Zoom. Mr. Parker, today is the date set for a pretrial on a domestic violence. Is there an offer?
Yes, Your Honor. At this time, the people have made an offer for the defendant to plead to an added count 2 of disorderly person jostling. And with that, I would leave it to the defense.
All right, this time we'd be requesting a second pretrial day so we can discuss that offer and then some new information.
Set up a final pretrial.
Thank you.
Pretrial November 20th at 8 o'clock in the morning in person at the court, okay?
Excuse me.
Yes, sir.
So like I'm lost on what's going on right now.
Have you spoke to your attorney?
No.
So that will explain why you're lost and what's going on today.
Yes, I haven't got a call from an attorney or anything since I've been released.
Mr. Raleigh, why is that?
Mr. Parker, I will speak to you later today, if that's all right.
Why is that, Mr. Raleigh?
I've not been able to reach him. Apologize.
Okay. Did you leave him a voicemail?
Not sure. I'm sorry, I don't know at this time, Your Honor. I don't have a note of that. I do apologize. That is my responsibility.
Okay. Do you have an accurate number for him?
Mr. Parker, I have a number ending in 5185. Is that accurate?
Yes.
That is a second pretrial.
All right.
we can leave that there. Yeah. Okay, so your attorney will make a contact with you. He's apologetic that he did not make contact with you before today's date. There has been an offer extended to you. He needs to discuss that with you and go over your rights, okay?
Okay.
Okay, and you will have another court date November 20th at 8 o'clock in the morning. If you have any concerns between now and then, you can make contact with the court, okay?
Yes, ma'am.
Okay.
It's crazy, bro.
You have another case after this?
I have Desmond Smith, Your Honor.
Desmond Smith present?
Yes.
Okay, Mr. Parker, hang tight. Your attorney's gonna log in just a moment, okay?
Okay.
The record in the matter of the people of the state of Michigan versus Desmond Smith, file number 23-02265, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Jacob Riley on behalf of Mr. Smith, Your Honor.
Okay, Mr. Smith, today's the date set for a plea. Let's see, there's one count of disorderly person drunk. Was there an offer, Mr. Brodowitz?
Not in so much, Your Honor. The offer would be more or less to plead to the count as charged. He would have no objection to HYTA status on it.
How did you find one of the plea?
Can't drink a plea today, Your Honor. I do have some paperwork. If I can go.
That's accurate, sir.
Yes, you are.
Yes.
You have an advice of rights and plea information sheet. It's dated for October 16th. That's your signature, sir.
Yes, sir.
Do you read this document?
Yes, I
You
can.
understand the rights listed here?
Yes, I do.
Do you have any questions about these rights? Are you willing to give up each of these rights today in order to plead guilty to disorderly drunk?
Yes, sir.
Okay. I don't remember if I swore you in. Did I swear you in? You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, sir.
Thank you. Again, so you understand these rights and you're willing to give them up today?
Yes, I do.
Okay, so that means you're willing to give up your right to the presumption of innocence. You're innocent until the prosecution proves you guilty, and they do that by proving each element of the charge being brought against you beyond a reasonable doubt at a trial. You understand that?
Yes, I do.
You have the right to a jury trial. You have the right to cross-examine or question any of the witnesses the prosecution intends to call. You have the right to confront those witnesses in court. And you have the right to call your own witnesses to trial or present evidence that you believe show a defense to the charge being brought against you. You also have the right to remain silent at trial and not have that silence be used against you. You want to give all of those rights up?
Yes, Your Honor.
Anybody threatening you to get you to give those rights up?
No, Your Honor.
Any promises being made to you if you give up these rights?
No, Your Honor.
Are you currently on probation or on parole?
Yes, Your Honor.
You're on probation?
Probation.
Okay, before which court?
This court, under Judge Buchanan, 54A.
Did you discuss with your attorney how this may have impact on your probation status?
Yes, Your Honor.
Okay, and you're willing to waive your rights, understanding that?
Yes, Your Honor.
Okay, and you also understand that a guilty plea could have impact on travel or immigration status you may be seeking?
Yes, Your Honor.
You also may need to report this to your current or future employer.
Yes, Your Honor.
How long do you on probation before Judge Buchanan?
12 months, 6 to 12 months.
When did you get to this 12-month probation?
It was in August, August 17th. August 1st.
Okay. Sounds. As to the charge of disorderly person drunk, how do you plead?
I plead guilty.
Actual basis, counsel.
Your Honor, Mr. Smith, on March 26th of this year, area of West Oakland and Cleo,
Yes,
is that in City of Lansing?
yeah.
that time, or had you consumed some alcohol?
Yeah.
Is it true that you were walking in the road causing a disturbance for some drivers at that time,
Yeah.
possibly creating a dangerous situation?
For me to get hit, yeah.
And you had contact with police at that time, right?
Yeah.
I believe,
Any questions, Mr. Brodowitz?
I don't believe I heard the defense answer, so I'll just ask, during that period, Mr. Smith, were you under the influence of alcohol at that time?
Yeah.
Okay. No further questions, Your Honor.
Court is satisfied with the factual basis. I will accept your plea. Find your plea to be made freely, voluntarily, and intelligently. Is he already on hideout before Judge Buchanan?
yes, sir.
Your sentence is 4 months probation. Will run concurrent with your probation before Judge Buchanan, so you're not duplicating anything. And I'll grant HIDA to the extent that you're eligible, but you're already on HIDA, so I'm imagining that you would be. Do you have any questions?
No, but I do got one statement.
Yes, sir.
I voted for you.
Oh, thank you.
For real.
Thank
Yeah,
you.
yeah.
Thank you very much. So when you leave here, you'll go down and you'll check in with our probation department. And then you'll continue your probation. You'll just, for the next 4 months, be on probation before both courts. Okay, sir?
Yes, sir.
Any additional matters for the record?
Nothing from the people, Your Honor.
No, Your Honor.
You're all set. Thank you.
Thanks.
On the record in the matter of the people of the state of Michigan versus okay, I thought that she's highlighted like choosing custody, so you were released. You can come up, ma'am. Shaniqua Wheeler, file number 23-02685, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Shaniqua Wheeler.
Somebody has a phone? Everyone's phone should be off. Today's the date and the time that's set for a pre-trial. I have one count of assault and battery, and then there's a bond violation. Was there an offer?
Your Honor, at this time, the offer would be to plead to the charge of assault and or assault and battery with no objection to HYTA status.
Mr. Lee?
Your Honor, we would like to set at least one more pre-trial to have further discussions with the prosecutor since the offer is essentially to plead guilty as charged.
November 6th at 10.
Would that be a second pretrial or a final pretrial?
He requested a second.
Okay, I just wanted to know.
10 a.m.
Yes. Do you have any questions today, Ms. Wheeler?
Yes, sir.
What's your question?
This is for the assault.
Yeah, this is for an assault and battery having allegedly occurred back on June 25th at the area of 2919 Cedar Street. I believe allegedly, is that a Family Dollar maybe?
I think so.
Okay, so you recall, do you have another question? What's the question?
Why were we doing another control?
Did you talk to your attorney?
That's probably why. Never mind.
Yeah. Any additional matters for the record?
Just your honor, with the PA 53 be reset for the same time?
That's correct.
Okay.
Any additional matters for today's record?
Nothing from the people, your honor.
Nothing for the defense. Thank you.
Okay, you're all set. We'll get you your notice to appear. Okay, ma'am? Okay, I see a Gregory Michael Lewis. I see April Reed. I don't see April Reed on my phone. Oh, she's not until 1:30. Why is she even there? Who's representing April Reed? Huh? Oh, she's at 1:30. Representing Mr. Lewis. On the record in the matter of the people of the state of Michigan versus Gregory Lewis, file number 23-00503, 504, 505, 506, 507, and 508. Council appearance.
Jeff Roberts on behalf of the people, your honor.
John Lee on behalf of Gregory Lewis.
Mr. Lewis, can you hear me?
I can hear loud and clear, Your Honor.
Okay, today's the date and the time that's scheduled for pre-trials on each of these files for dog license vaccination matters. Was there an offer on this, or do we just need time for him to bring these into compliance?
At this time, your honor, according to conversations with defense counsel, Mr. Lewis is no longer in possession of those dogs. So at this time being, as he's no longer in possession, the people dismiss at that point.
Okay, each of these files are dismissed. You're all set, Mr. Lewis.
Thank you so much, Your Honor.
You're welcome.
Is it okay for me to leave then?
That's correct.
All right, thank you.
You're welcome. April Reed is present. This is just an arraignment. Is that what it is? Bring me the file, I'll arraign her. Ms. Reed, can you unmute your device, please? On the record in the matter of the people. Of the state of Michigan versus April Reed in file number 22-02159. Ms. Reed, you actually were not supposed to be here till 1:30, but I'm gonna go ahead and arraign you now. I have a request and summons for probation violation. The allegation, ma'am, is that you engaged in assaultive or threatening behavior. You displayed assaulting or threatening behavior back on September 3rd, 2023, and then on September 24th, 2023. So you have the right to be represented by counsel, and you have the right to have a contested hearing. If you're found to be in violation of the probation terms, your probation can be extended, your probation can be revoked, you can be sentenced to a term of jail time, or you could have other oversight or sanctions imposed for the sentence of the alleged violation, okay?
Okay, ma'am.
Okay, so you have the right to have a contested hearing, and you have the right to be represented by an attorney at that hearing. Did you want to have an attorney represent you for this?
Yes, ma'am.
Okay, so I'll note that you're requesting court-appointed counsel, and we will set this matter for a probation violation hearing in person. October 30th at 1:30 in person at the court is your hearing, okay?
Yes, ma'am.
Okay, do we have, Mr. Lee, you have someone else here right now?
I do not, Your Honor, unless Mr. Carter is here.
Mr. Carter is not here. Ms. Reed, what's your number? What's your phone number?
Oh, my phone number is 517
Yes.
85-5605.
Repeat that, it cut out a little bit.
517-885-5605. Do you want me to give you my fax as well?
Nope, someone from the public defender's office will be in contact with you, okay?
Okay, thank you.
You're all set, thank you.
Thank you, ma'am.
You're welcome. Are you all waiting for court dates, or you waiting for someone else? People behind you.
Mr. Christie is here.
He's with Mr. Dudley, but Mr. Dudley is not here.
Okay.
Mr. Kristen, just need a. On your end?
Mr. Christie needs a new date.
Yes,
He has private counsel.
I believe he's representing himself here.
Mr. Dudley.
Mr. Lee. It's up to the prosecutor, Your Honor, my understanding.
Mr. You mean Dudley Carter?
Yes.
Okay, okay. Mr. Christie needs a new date. What's the new date for?
For compliance purposes, Your Honor.
How much time?
I'll be back here on 13th, 8:30.
Okay. Yeah, and I think
I'm just gonna send you some pictures now.
Yeah. Yeah, so he'll be here, I believe, across the hall for Judge Flores on the 13th at 8:30. So we can set it for November 13th at 8:30.
November 13th. If he's, I'm sorry?
Or sorry, but November 13th, not at 8:30, but on November 13th, if that would be.
Oh, he has a city matter before us.
Yes, but before Judge Flores, so he will be here. I anticipate,
At what time? November 13th at 9.
I anticipate being able to, if Mr. Christie gets me the pictures, to be able to acknowledge these prior to that, Your Honor.
Okay, we'll get you your notice to appear, okay, sir?
Thank you, Your Honor.
You're welcome. On the record in the matter of the people of the state of Michigan versus Dudley Lamont Carter, file number 23-01712. Council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Dudley Carter.
You say Mr. Carter's not here?
No, Your Honor. I don't know if the court would be willing to waive his appearance. It was my understanding that the prosecutor was going to dismiss the case today.
Yes, Your Honor, I've spoken with the complaining victim in this matter. I did prior to the final pretrial we had previously scheduled in this matter, and where Mr. Carter originally failed to appear, and then again, I spoke with him on Friday. It is the complaining victim's desire not to proceed in this matter, Your Honor, and so at this time, the people would be moving, would not wish to proceed either, and so the people would be moving to dismiss without prejudice.
Okay, I need an ollie. going to be seeing Destiny Johnson. Yeah, counsel. Your office is not representing Ms. Johnson, Mr. Lee?
I am not representing Ms. Johnson. I don't believe.
Okay. Each more bond forfeiture.
I believe she had representation for Johnson.
I don't have an appearance on this file, though. What's your name?
Sutter.
Ready to proceed?
Just one second, Your Honor.
I need to speak with her.
Because I believe Mr. Doyle was on this last time.
Yeah, a couple of years ago, I think.
Well, he showed up
She
last
felt
time.
with it.
Oh, you did? I don't know where they sucked it out, but.
Oh.
Yeah.
Are we just waiting on the jury at this point? Yes.
Yeah. That's-
So you- No, no objection.
Your Honor, if I need to use the restroom, would it be better to do it now or after the jury comes up?
Probably now. Hi.
Sorry. Yeah, yeah, yeah. Well, we'll grab some tea.
John Watson. Is that a witness?
No, he has a dog at, 2 counts of dog at large.
The man, I'm talking about the man who just left.
Oh, no, he, that was a witness for PA 53 for Miss Wheeler.
Okay.
Officer.
Yes, Your Honor. It's John Watson. I'm here.
Okay, okay, do you have an attorney?
No.
Okay. You were looking for some compliance or something?
That would be the offer.
You can, yeah, if you want to log in, I'll put you in a private meeting room. If you're representing yourself, I'll put you in the private meeting room with the prosecutor so he can talk to you about how you can resolve this matter, okay?
Okay.
Person identified as Benjamin Hilborn. Are you Benjamin Hilborn?
Yes, Your Honor.
Okay, where are you, sir?
I'm at Act Louisa on Louisa Street in Lansing, Michigan.
Okay, Mr. Brodowitz, let me put you in room 2 with Mr. Watson. When the prosecutor comes back, we can call your case.
Okay, it's gonna be a plea.
Who's representing Mr. Hilborn? Is it you or Mr.?
That is me. Your Honor.
Okay, we need his fingerprints.
That's gonna be a plea as well. Would you do that today or set it for a day?
Set it for, there's a reason why he's appearing via Zoom and can't come in person.
I don't know if there's a specific reason, Judge.
We'll set it for a plea because we need his prints.
Right, okay.
Mr. Hilborn, we're gonna set your matter for a in-person plea. We need you to get your fingerprints taken care of, okay?
October 30th at 9.
October 30th at 9:30.
Okay.
Do you have any questions today?
No, I do not, Your Honor.
Okay, you're free to go.
Okay, thank you.
You're welcome. What's your name? You're supposed to be here at 10 o'clock?
They told us to sit out there or come in. I sat out there, so I talked to my lawyer. Yeah.
Who's your lawyer?
I'm not sure.
Who told you to sit out there?
The lady at the window, because they didn't have.
The prosecutor, oh no, it says she does have a public defender. It must be Mr. We have a appearance by a Joseph Hardy. This can't be accurate. This is the wrong, this has to be on the wrong file because it says Judge Buchanan on it.
Yeah, they changed the stuff.
Oh, no, it's the same file number.
It was originally.
Buchanan's file, okay. Joseph Hardy, I don't know who that is. And, oh, okay. Okay, well then, I don't see, is Mr. Riley out there or Mr. Lee? defender out there?
I don't know where they're going.
Let me get the new picture for her. 6 at 10. Who's identified as Zoom user? Can you hear me with the grand leg shirt? Yeah, you're wearing a grand leg sweatshirt, correct? You can't hear me. Sir, can you hear me? Hello?
Hello?
Did you hear me talking?
Yeah, I hear you, but I'm not wearing a green t-shirt.
I said grand ledge.
Oh, Grounded, sorry. I thought you said light green t-shirt. My bad.
No, is your device name Zoom user?
Yes.
Yeah, I said who's identified as Zoom user. You didn't respond. I said who's wearing the grand ledge shirt. You didn't respond.
I'm sorry. Yeah, my name is John. First name is John. Last name is Remy, Habumuri.
Okay. Do you have an attorney?
No,
Did you request court-appointed counsel?
okay, there we go. Sorry?
You were denied a public defender. Do you know that?
Yes, they called me and let me know that.
Okay, what's your plan? Are you gonna hire an attorney?
Yes.
How much time do you need to hire an attorney?
Probably a few months.
We're not gonna give you a few months. You can get a few weeks. Have you contacted an attorney?
I'm trying, yeah. I've been trying, yeah.
Okay, well, let me reset this and you'll come in a couple of weeks and show me what progress you made.
Okay.
November 6th at 10. November 6th at 10.
November 6th at 10.
That's correct.
Coming in or via Zoom?
You can do via Zoom.
Okay.
Do you have any questions today?
No, I don't have any questions at all, ma'am.
Thank you. You're all set for today.
All right, thank you, ma'am.
You're welcome. So we can't find a public defender at this time? On the record, in the matter of the people of the state of Michigan versus John Watson, the third, file numbers 23-07-02705 and 706, council appearance.
Jeff Brodowitz on behalf of the people.
Okay, Mr. Watson, you are representing yourself. You're present via Zoom. And I have 2 counts of dog at large. You did speak with the prosecutor and he's advised you of how you can have this matter resolved. So are you looking for time to do that?
Yes. If I may, Your Honor, at this time, if I may, Mr. Watson did show me, he does have a fenced-in yard, and he explained to me that this was due to the latch on his fence breaking after the large storms we had a few weeks back. He showed me the steps that he's taken to secure the dogs in the yard since that. And so at this time, the people are satisfied and move to dismiss for compliance.
Okay, the motion to dismiss is granted. These matters are dismissed, so you're all set.
Thank you. God bless y'all. Have a good day.
Same to you. Who's that? I just left.
That was Anthony Price, who was set for final pre-trial.
Well, that was not where I was looking for a public defender. That's the young lady that was sitting back there. She gave her a new date? Yeah. Did the young lady that sat back there left?
Destiny Johnson?
Yes.
Yeah.
Do you represent Destiny Johnson?
No, you're.
Someone from your office does. Mr. Lee told me he didn't either.
Let me check that.
We have an appearance.
For sake of conflict attorney was assigned to that judge.
Who is the attorney?
I'll see if we have. Looks like David Carter.
I wonder if he was aware. Huh?
I don't believe so, Your Honor, because I saw him earlier this morning in Judge Flores' courtroom.
Yeah, I don't know that he was aware of that. Okay, we'll get him notice of the next court date. Thank you. Let's see. On the record in the matter of the people of the state of Michigan versus Angel Sutter. File number 19-04-895, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Matt Samuels on behalf of Ms. Sutter, who is present and on Zoom. I guess probably calling for the jail.
Okay, Ms. Sutter, today's the date and the time that's set for a pretrial on a retail fraud. You said this was going to be a plea, is that correct, Mr. Samuel?
It is, Your Honor, and I do have a plea sheet that's signed by both myself and the people.
Thank you. Okay, Ms. Sutter, please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
I'm sorry?
Yes, I do.
Thank you. You can put your hand down. Okay, I have here a plea sheet. It says the people are offering for you to plead guilty to an added count 2 of trespass with restitution in the amount of $200, and that the people are seeking to dismiss the original count 1. There's a killer brew of fines and costs. Is that your understanding of the offer?
Yes, it is.
Okay, you want to accept it?
I do, ma'am.
Okay, so you understand that you have the right to the presumption of innocence. So you're innocent until proven guilty?
I do.
And you want to give that right up?
Yes, I do.
You have the right to a jury trial. You have the right to remain silent at jury trial and not have silence be used against you. You have the right to require the prosecution to prove your guilt at that trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question in court any of the witnesses the prosecution intends to call against you, and you have the right to call your own witnesses or present evidence that you believe further a defense to the charge being brought against you. You understand each of those rights, correct?
Yes, I do.
And you're willing to give up all of those rights today to plead guilty to trespass?
That's correct. Yes,
Okay,
ma'am.
Anybody threatening you to get you to plead guilty?
They did not.
Any promises being made to you in exchange for a guilty plea?
No, they did not.
Okay, what are you in custody for?
I'm in custody because I was walking across the freeway and I had a warrant, so I had to. That's why I'm here now. I got court the 26th.
So you only, I remanded you on this file. Are you being held on anything else?
I just got to get sentenced from Judge Allen on 26.
Okay, sounds good. You understand that a guilty plea could result in the conviction that may have impact on travel or immigration status that you may be seeking.
I do, ma'am.
Due to the age of the file, this could not possibly have any impact on any other status that you're on, such as if you were on probation or parole. But you understand that a guilty plea could have some impact on your probation or parole status if you were on probation or parole?
Yes, ma'am.
Okay. Are you entering a guilty plea to trespass because you believe you're guilty?
Yes, ma'am.
And you understand and agree to pay restitution in the amount of $200?
Yes, that's correct.
Okay, as to the amended or the added count 2 of trespass, how do you plead?
I plead guilty.
Factual basis, please.
Yes, Your Honor, I'm gonna use the factual basis on the original charge, which is the retail fraud second.
Thank you.
Ms. Sutter, on or about April 23rd, 2019, were you at the Myers at 6200 South Pennsylvania?
Yes, I was.
And at this time, and to the best of your knowledge, is that in the city of Lansing, County Hingham, state of Michigan?
Yes, it is.
And
Yes, it is.
did you assist somebody, or steal yourself some property from Myers that was for sale?
Yes, I did.
And you didn't have permission to do this?
That's correct.
And this was during normal business hours for Meyer?
Yes, it is.
And the items that were attempting to be stolen, or the items that you did steal, those were for sale by Meyer during their normal course of business as well?
Yes, it was.
I have nothing further, Your Honor. I think that satisfies the factual basis.
People are satisfied with that factual basis.
Thank you. The court is also satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. A sentence is credit time served plus restitution to Myers in the amount of $200. Any additional matters for the record?
Nothing from the people, Your Honor.
Nothing further from here, Your Honor, either.
You're all set. Thank you, Ms. Sutter. Lorraine Thomas, present. Have you seen Lorraine Thomas? No? You're free to go, Ms. Sutter.
Okay.
Oh, we got a new one. Thank you. There's no one out there for Lorraine Thomas? Okay.
Judge, have the rest of your day.
Thank you. Okay, is the jury here?
No, Susan said she's coming. That is Mr. Price from
Okay. Does everybody have a seat? Probably not. Seat number 1 is going to be Amber Nicole Suter. You're going to walk around this way. You're going to go to seat number 1. Number 2, Corey Chaffee. Number 2. Number 3, Jessica Yergin. What's your name, ma'am? Number 2? Chafin?
Jesse Yergin.
Thank you. Okay, number 4, David Bonham. Number 5, Lori Warner. Number 6, Juwan Anderson. Number 7, Denny Kraus. Okay, you can be seated.
Sorry.
Okay, so I did do before we're on the record in the matter of the people of the state of Michigan versus Lalonde Lemus, file number 23-00761. Council appearances.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender John Lee on behalf of Randy Lemus.
Okay, and today is the date and the time set for jury trial. The jury is present. We do have 7 members of the jury pool in the gallery. I'm going to go over some instructions, so everyone can turn their attention to the screen here. Okay, ladies and gentlemen, good morning. I am Judge Kristen Simmons, and it is my pleasure to welcome you to the 54A District Court, Lansing, Ingham County. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of the Free Society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have a right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a jury trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with jury selection. The purpose of this process is to obtain information about you that would help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are not meant to find out if you know anything about this case. The questions are meant to find out if you know anything about this case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may otherwise be qualified to be a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of two ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason to do so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as jurors in this case. If you have religious beliefs against taking an oath, you may affirm that you will answer all questions truthfully, fully, and honestly. Jury, please rise. That includes you all. Thank you. Please raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all the questions about your qualifications to serve as jurors in this case? Yes. Thank you. You can have a seat. Okay, let me first introduce my court staff. I have Miss Addie Nash, that is my court recorder. She's sitting to my right. And then Mr. Nicholas Bigelow is my court officer. This is a criminal case involving the charge of aggravated assault, which I will explain more fully later. This charge has been made against the defendant, whose name is LaRondi Lemus. The defendant's attorney is John Lee. Mr. Lee, please stand. List any witnesses you anticipate calling in this trial.
Thank you, Your Honor. The defense intends to call Mr. Dwayne Dodge, Ms. Nevaeh Venus, and we reserve the right to Ms. Lorraine Lemus testify as well.
Thank you. And the assistant prosecuting attorney is Jeffrey Brodowitz. Mr. Brodowitz, please stand and list any potential witnesses you anticipate calling at trial.
Thank you, Your Honor. Good morning, everyone. My name is Jeff Brodowitz. I'm the assistant prosecutor here in this matter. The witnesses I anticipate calling are Ms. Sunshine Wheatley, Mr. Demori Watley, and Detective Tasha Oswald.
Thank you. We expect this trial to last one day. If there's a potential that this may run over till tomorrow, though. If you believe that the length of the trial may or could be a real hardship for you, please let me know now by raising your hand. Yes. What is the hardship?
I don't know if I'm comfortable
You're comfortable with what?
with like being here.
Okay, why is that?
I have like social anxiety.
Okay, you suffer from some anxiety? Okay. And so you don't typically go into settings with other people? Is that what you're saying? Would you suggest just for stating, what is your name, sir?
Juwan.
Okay, and you're employed, sir?
Yeah.
Okay, and you work by yourself?
No, I work at the Courtroom.
I'm sorry?
It's a factory.
Okay, so there's other people in the factory? Oh, okay. Probably more people that's in this courtroom is works at that factory?
Yeah, it is like closeness.
Gotcha. Okay, sounds good. I'll keep that in mind.
Thank you.
Thank you. Anybody else believe that the length of trial could potentially be a hardship? Okay, very good. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have any medical problems that make you unable to sit for 2 or 3 hours at a time? Or does anyone have a sight or hearing problem. So first, can everybody hear me?
Yes.
Okay, raise your hand if you can't hear me. Raise your hand if you can hear me. So everyone can hear me. And everyone can see clearly. It's a small courtroom, so that shouldn't present a major issue if there's exhibits. And then what about medical problems? I can't sit for long periods of time, and it's not because I have a medical problem. It's just too long to sit. So we typically take a break if we go longer than an hour straight, okay? But anybody that have a medical issue that would prevent them from being able to sit for an hour at a time. Okay, very good. Any other medical or health problems that would prevent you from serving today? This is a criminal case. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges the defendant, Lorendi Lemus, as follows. It says on or about April 19, 2022, at the area of 23237 Avenue, which is in the city of Lansing, Ingham County, state of Michigan, that the defendant allegedly, contrary to law, commit the act in count 1 of assault aggravated, and that she did allegedly make an assault without being harmed with or armed with a weapon upon a Sunshine Wheatley, and did inflict a serious or aggravated injury upon said person, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. And this is contrary to Michigan Compile Law 750.81A1. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal case so that the defendant and the jury can hear the charges. You must not think it is evidence of her guilt or that she must be guilty because she has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. Okay, so now we will continue with voir dire. And so, Mr. Brodowitz, you may proceed with your question briefly.
Thank you, Your Honor. Good morning again, ladies and gentlemen. Like the judge said, we're just trying to, learn a little bit more about you. We're not trying to, embarrass or, really pry into anybody's private lives. We just want to get the best jury up here to have a fair and open, honest trial. So has anyone currently in the jury box ever served on a jury before? With Miss Chafe, what type of jury was it? A criminal or civil?
It was,
Can you just speak up a little bit? They have to record,
sorry.
they're recording everything, so they can kind of, can you just speak up a little bit?
Sorry, it was a criminal.
Okay, do you recall what the case was about?
That,
Okay, and were you able to reach a verdict in that case?
yes.
Okay. Do you remember what that verdict was? Okay. And then before Mr. Bonham, a civil or criminal jury?
Criminal.
Okay, do you recall what type of case it was?
Yeah, it was for rape.
Okay, and were you able to come to a verdict on that?
We were not.
Okay. And then I saw one more. Okay, sorry, Mr. Rouse? Yeah. What type of jury, civil or criminal?
It was criminal.
Okay.
It was a guilty verdict, but I don't remember what it was about. It was quite a few years ago.
Okay, fair enough. Does anybody know I should just ask in general, anybody here sitting at this table, myself, Mr. Lee, the defense attorney, the defendant, Ms. Lemus.
I think I worked with Ms. Lemus.
Okay. And is there anything about working with Ms. Lemus previously that would make you unable to be fair and impartial here today?
No,
Okay. I thought I may have seen one more.
You said you worked with Ms.
I
Lemus?
believe so. If it's who I take, if you work at Aria or the Willows.
Yes.
Yes.
Okay.
Nursing homes.
But nothing about that relationship.
No, I don't
Okay.
remember much.
No. I think one of the jury's instructions was, do you know her?
I don't think it ever got read.
I'm sorry?
I said, I don't think we ever went over it. It was on the slide.
Give me just a moment, Mr. Brodowitz.
Yep.
Okay, is anyone in the jury box or waiting to get in the jury box? No, the defendant or any of the lawyers or of the witnesses named? And you said yes. Thank you. You know who?
Yeah, Nevaeh.
You know Nevaeh?
Yeah,
Okay. And how do you know Nevaeh?
we worked together at Big Dog.
Okay. And then you know whom? Okay. And your name?
Crystal Gaylor.
And then last name again, sir, you're Mr. Anderson? And then juror number 3. Okay. Okay, juror number 3, you may be excused. Archibald Davis replaced juror number 3. Juror number 6, you may be excused. Sammy File replace number 6. And Ms. Gaylor, you may be excused. Thank you.
Sorry, Your Honor, I think I might have some confusion on my name list here. I have seat 1 as Andrew Suter, seat 2 is Corey Chaffee, seat 4 is David Bonham, seat 5 as Lori Warner, seat 6 is Tammy Files, seat 7 is Danny Kraus. I didn't catch the name of seat 3.
Archibald Davis. No problem. Okay, Mr. Broadus, you can continue.
Thank you, Your Honor. Okay, so for Ms. File and Mr. Davis, you heard my just my couple of previous questions. Have either of you served on a jury before?
Numerous times.
Okay, civil or criminal jury? Okay, and on the criminal cases, were you able to come to resolutions in those cases?
Yes.
Okay. All right. Does anyone currently sitting in the jury box have any friends or family members who are members of law enforcement?
No.
Friends or family? Close, actually, it's close friends or family. Okay, what's your friend do? Okay. And would that relationship cause you to be more or less, would you hold the testimony of a law enforcement officer? Would you give that more or less weight than any other testimony based on that relationship? And do you think based on that relationship, you can be fair and impartial here today? Okay, and then Mr.
I
Bonham?
can't hear her.
Yeah, if you could speak up, please.
Yes, I can. There.
Okay. And then Mr. Bonham, you know someone in law enforcement?
I had about half a dozen friends,
Okay,
very close friends, yeah,
and who do they work for?
all the way to.
Okay, and would the relationship with them cause you to give any more weight to a police officer or not?
I don't think so.
Okay,
No.
do you think then you could be fair and impartial here today?
I do.
Okay. Does anyone here, okay, so as the judge said, defendant Ms. Lemus has been charged with the crime of aggravated assault. Has anyone ever heard of aggravated assault? Okay. All right. Has anyone here ever had a family member that has either been a victim of or has been accused of some sort of assault crime, aggravated assault, assault and battery? Miss Warner, I believe. Yeah. Accused of or victim? Okay, both. Were any of those cases ever prosecuted?
Yes.
Okay. And would your experience having people, I guess, that have been on both sides of it, with that experience, would you be able to be fair and impartial here today?
I believe so, yes.
Okay. So as the judge will instruct you in a little bit, the crime of aggravated assault has 3 elements. First, that the defendant tried to physically injure another person, that the defendant intended to injure the specific victim in this case, and that the assault caused a serious or aggravated injury, which you will have the definition of in the jury instructions. I just wanted to ask what, just briefly, really quick here, I'll ask Mr. Kraus, what to you would be a serious or aggravated injury?
What would I think would be?
Yeah.
Deliberately shoving someone, causing them to fall.
Okay. And then Ms. Suter, what in your mind would constitute a serious or aggravated injury?
Injury,
Yeah.
something that could be potentially fatal or life-threatening.
Okay. So the definition that you will be provided is that a serious or aggravated injury is any physical injury that requires immediate medical treatment or causes disfigurement, impairment of health or impairment of a part of the body. Is everyone satisfied with that definition? Everybody understands that definition? Okay. So one of the elements that will need to be proved in here is the defendant's intent. Now, Ms. File, what type of evidence would you need to see to know someone's intent?
I'm not really for sure what the question is.
Okay, so you'll have to, as a juror here, you'll have to determine what the intent of the defendant was as one of the elements of the crime here. So what type of evidence would you need to see to determine what someone intended to do?
Thought out.
Okay.
I don't know what I'm doing.
For their thought process a little bit.
Yeah.
Mr. Davis, what would you need to see?
Can you repeat the question, please?
What type of evidence would you need to see to know someone's intent?
Either written out or acting on.
Okay. And so if, based on that, if, you're going to hear testimony here today about the incident that happened, does everyone believe that they would be able to determine the defendant's intent from the actions and facts that you'll hear today? And then, in general, does everyone understand the difference between an intentional act and an accident?
Yes.
Yes.
Okay. All right. So as to the evidence you'll hear today, there may be some exhibits. A lot of it will be testimony from witnesses. Is anyone expecting any sort of independent, eyewitness to come forward with, the 100% perfect memory, the, aha, this is exactly what happened? Okay. Is anyone expecting any sort of, high-tech evidence, sci-fi stuff you see on TV? Okay. And does everyone understand that, as most of the evidence here, I believe, will be testimonial evidence, that people have, that this evidence comes from people have varying emotions, varying motives, and unperfect memories? Does everyone agree with that? And do you think, as jurors, you'll be able to, based on what you hear here today, listen to the testimony and come to a fair judgment here today?
Yes.
Okay. Does everyone understand that when judging witness testimony, you will have to, as the jurors, make decisions as to credibility of the witnesses? Do you understand that the credibility and believability of the witnesses is something that only you as jurors can make?
Yes.
Okay.
Yes.
So one of the other things is that I will, and the judge said this a little bit, but I will have to prove my burden in this case beyond a reasonable doubt. So let me ask just really quickly here, Mr. Bonham, what to you qualifies as beyond a reasonable doubt?
Some kind of evidence or documentation of what happened. The witnesses saying relatively the same thing.
Okay. And then Mr. Kraus, what to you would be beyond a reasonable doubt?
Physical evidence, seeing whatever happened, the result of that.
Okay. So let me, I just want to give you a brief little analysis here. So if you wake up in the morning and you see that, the sidewalk outside is wet, the grass is wet, would it be reasonable to look out and assume that it had rained that night? Okay. But is it not also possible that over the night while you were sleeping, that there was a person standing up on your roof with a hose who was spraying your grass and your sidewalk with water, correct? Okay, is that possible? I see Miss Filey, or sorry, not Miss Filey, Miss Warner, I think you're shaking your head a little bit. Is it possible that someone was doing that?
Crazy.
Okay, fair enough. But I guess would the person standing on your roof then be reasonable? Okay, so that's the standard we're looking for here, is it's not beyond all possible doubt, it's beyond a reasonable doubt. Is everyone okay with that standard?
Yes.
All right. And then as to one of the issues that comes up and people have thought about is punishment in cases like this. Now, ultimately, punishment is solely the determination of the judge in these matters. Is everyone okay with that?
Yes.
Okay. And so would anybody here take punishment into account when you're back there doing your deliberations?
No.
Okay. No other questions at this time, Your Honor.
Mr. Lee?
Morning, everybody, and thank you for being here. My name is John Lee. I'm an assistant public defender here in Eden County. This is my client, Lorraine Lemus. She will be the subject matter of our discussions today. You've heard some talk about this concept of reasonable doubt. There's a reason why that's being discussed, because that's going to be the primary focus of the defense's case in chief. We are going to assert some things that we believe cast significant reasonable doubt on the complaining witnesses. So I want to revisit that for just a minute. On a scale of 1 to 10, how strongly would you have to believe that something is true for it to be beyond a reasonable doubt? 8 to 10. 8 to 10. Anybody else got to see a lot of people shaking their head? How many? 7, 8. 7 or 8. Okay. Anybody else?
9 to 10.
I'd submit to you that it would be, my opinion of it, would be that it would be a little bit higher, 8, 9 or 10. Reasonable doubt is a big, big burden. It's one thing that makes the US justice system unique. You know, a lot of other places around the world, if they can just get one person to say it, that's enough. Sometimes they don't even need that, right? But here, we require it beyond a reasonable doubt. So, what would be a sign that something might not add up? What might you look for? Conflicting stories, okay? Sure. Anybody else got anything else? Witnesses who don't seem credible, sure, yeah. These are all the types of things that we as lawyers think about too, so you guys are right on the right track. I don't have any further questions, thank you.
Thank you. Mr. Brodowitz, any challenges for cause?
No challenges for cause, no.
Mr. Lee, any challenges for cause?
No challenges for cause, Your Honor.
Mr. Brodowitz, any preemptory?
Yes, Your Honor, at this time, the people would like to thank and excuse juror number 7.
Thank you, juror number 7, you may be excused. Mr. Lee, any preemptory?
Yes, Your Honor, we would like to thank and excuse juror number 5.
Thank you, juror number 5, you may be excused.
Oh, yeah.
Okay, and seat number 7, Rebecca Renee Lott. Number 5, Dominique Starr. Okay, and so you all have heard the questions that was previously asked. Did anybody want to provide any responses to any of those questions now that you're in the hot seat? That goes for you, juror number 5 and juror number 7. Okay, you can proceed with any further.
Just to go back over just a couple of, and again, specifically directed to Ms. Starr and Ms. Lott. Have either of you, do either of you have any friends or family in law enforcement?
No.
Okay, and does any friends, do you have any friends or family, anybody you know who's been either the victim or been accused of any sort of assaultive crime before?
Yeah, no.
Okay, accused or victim?
Victims.
Okay, and what were they victims of?
Domestic violence.
Okay, and having that history of friends with being victims of domestic violence, would that impact your ability to be fair and impartial here today? Okay. Other questions?
Okay, and Mr. Lee, any specific questions you wanted to go back over with these 2 jurors?
Thank you, Your Honor. Ms. Starr and Ms. Lott, I want to ask you that same question in regard to the reasonable doubt question. Scale of 1 to 10. How does that fall for you? 9? 9? Did you say 10?
Yeah.
Mr. Brodowitz, challenges for cause.
No challenges for cause, Your Honor.
Mr. Lee, any challenge for cause?
No challenges, Your Honor.
Mr. Brodowitz, any preemptory?
People are satisfied with this jury, Your Honor.
Thank you. Mr. Lee, any preemptory?
No, thank you, Your Honor. We're satisfied as well.
Okay, ladies and gentlemen, we have a jury. To the remaining of you all who did not make it to serve today, I do apologize that you're going to miss out on this experience to fulfill one of your most fundamental civic duties. There are chances, however, for you to do that tomorrow. So you are going to be able to be released back into the custody of our Deputy Court Administrator, and we will see you next time. Thank you. All rise. Okay. And you can be seated.
Your Honor, the defense does has one question about the instructions. I don't know if this is something you can do in front of the jury or not.
You can approach. We don't have a sequestration order, do we?
Not at this time, Your Honor.
Okay, thank you. Okay, ladies and gentlemen, I have some further procedural instructions for you. Ladies and gentlemen of the jury, you have been chosen to decide a criminal case or a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try this case justly and to reach a true verdict. If your religious beliefs do not permit you to take the oath, you may instead affirm to try the case justly and reach a true verdict. Please rise and raise your right hand. Do each of you solemnly swear or affirm in the action now before the court you will decide justly the question submitted to you, that unless you are discharged from the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court? If you do so, please say I do. I do. Thank you. You can be seated. You will get a written copy of the instructions I'm going to go over at the end when it's time for you to deliberate. So you won't be able to refer to them during the trial. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. I apologize for this issue. It only happens when we're doing jury instructions, and IT hasn't figured out why. So the screen is gonna go in and out on your behalf. Okay. Neither are potential witnesses behind us, is that correct? Mr. Lee?
Yes, I have one witness here.
Okay, there was not a sequestration order asked. I'm going to enforce one. So any potential witnesses need to step out.
I was gonna ask them before testimony.
I just issued one. Oh. Now I will explain some of the legal principles you will need to know and the procedure we will follow in this trial. First, the elements for a assaults, that being in this matter an aggravated assault, is first, the defendant is charged with the crime of assault and infliction of serious injury, which is also known as aggravated assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant tried to physically injure another person. Second, that the defendant intended to injure Sunshine Wheatley or intended to make Sunshine Wheatley reasonably fear an immediate battery. Third, that the assault caused a serious or aggravated injury. A serious or aggravated injury is a physical injury that requires immediate medical attention or treatment, or that causes disfigurement, impairment, or health or impairment of a part of the body. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 19, 2022 within the city of Lansing, Ingham County. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyers has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyers will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict solely on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any facts in the case is final. Part of your job in deciding what the facts of this case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on a witness's race, national origin or ethnicity, gender, gender identity, or sexual orientation or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to make an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influence that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? When it is time for you to decide the case, you are allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts in the case. You are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, and pass it to my court staff, which will be my court officer here, who will give it to me. Do not show your questions to the other jurors. Everyone should have had a notepad and a pen. Is that correct? Very good. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand, and that should say immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyer or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have discussions out of your hearing. Also, while you're in the jury room, I may have to take up other matters that have nothing to do with this case. Please pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave. Report the incident to my court staff as soon as you return to court. When the trial is over, these restrictions no longer apply, and when the trial is over, you may, if you wish, discuss the case with anyone. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So, to be fair to both sides, you must follow this instruction. The restrictions I am about to discuss are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider must meet certain standards. For example, witnesses must swear to tell the truth and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty as a juror to decide this case based solely on the evidence you see and hear in this courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You must not.
I'm listening, Ms. Ruby needs to use the microphone.
I'm sorry.
It would be okay for him to be excused.
And you can't wait another couple minutes, is that what you're saying?
I'm expecting to come home down.
Okay, thank you. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated my instructions, report it to my court staff. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see we've chosen a jury of 7. After you have heard all the evidence and my instructions, we will draw names as to which one of you will be dismissed to choose a jury or form a jury of 6. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix a penalty within the limits provided by law. I may give you more instructions during the trial. After all the evidence has been presented, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken together, they are the law you must follow. After my final instructions, you will go to your jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it and it must reflect the individual decisions of each juror. It's important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have unintentionally been influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. Okay, we're going to take a brief recess, 5 minutes, and then we'll proceed with opening statements. All rise, the jury should exit first. All rise for the jury. Okay, you can be seated. Okay, Mr. Barwood, you can proceed with your
Your Honor.
opening statement.
Good morning, ladies and gentlemen. Ladies and gentlemen, during this trial, you're going to hear about a violent relationship, specifically the relationship between the defendant, Miss Lorandi Lemus, and the victim, Miss Sunshine Wheatley. This case, which is the assault of Miss Sunshine Wheatley, is a consequence of that violent relationship. On April 19th, 2022, near 7th Park, which is in the city of Lansing in Ingham County, I believe while at the store, the defendant, Lorandi Lemus, would participate in the assault of Miss Sunshine Wheatley, assaulting her with a firearm and breaking her hand. As a result of the defendant's assault on April 19th, 2022, she is charged here with the criminal offense of aggravated assault. As the prosecutor, I have the burden in this case, as we stated earlier, and that I must present evidence to you that a crime was committed and the evidence that the defendant committed that crime. Additionally, and as you've sort of already been instructed, every crime is made up of a series of things called elements. I want you to consider these elements as sort of a checklist of the requirements that I have to hit. With that, I briefly want to go over with you again what aggravated assault is. For someone to be guilty of the crime of aggravated assault, first, the defendant must have tried to injure another person. Second, that the defendant in fact specifically intended to injure the victim here, Miss Sunshine Wheatley. And third, that the assault caused a serious or aggravated injury. And a serious or aggravated injury is a physical injury that requires immediate medical treatment or causes disfigurement, impairment of health, or impairment of a part of the body. At the conclusion of this trial, I'll speak with you again during closing statements, and I'll explain how all of the evidence presented here relates to that charge and the specific elements there. Based on the anticipated evidence, I will submit to you that the defendant, Lorandi Lemus, is guilty of the charge of aggravated assault. And so, ladies and gentlemen of the jury, the evidence I expect that you will hear in this case that details the assault of Miss Sunshine Wheatley is specifically that on April 19th, 2022, Miss Sunshine Wheatley and her boyfriend were at the store near 7th Park in Lansing, that Miss Sunshine Wheatley and her boyfriend exited that store when Miss Sunshine Wheatley was attacked by a Miss Alexis Mejia and Miss Nevaeh Lino Lemus, the daughter of Miss Lorandi Lemus. I also expect that the evidence will show that during this assault, Miss Sunshine Wheatley's boyfriend attempted to jump in and protect her from that assault. And when he attempted to protect his girlfriend from that assault, Miss Lorandi Lemus joined in the assault with a pistol, struck Miss Wheatley on the hand, and caused an injury needing immediate medical attention by breaking her hand. During this trial, I anticipate you'll hear from both Miss Sunshine Wheatley and her boyfriend, Mr. Damari Wheatley. I'm sorry, Damari Watley. My apologies. I anticipate that you will learn that this assault began as a result of the conduct of Miss Lemus's daughter, which caused, as I stated previously, Mr. Watley, Miss Wheatley's boyfriend, to jump in and defend her, ultimately leading to Miss Wheatley's broken hand as a result of being struck by the handgun wielded by Miss Lemus. So with that, ladies and gentlemen, at the conclusion of this trial, I will ask you to hold the defendant accountable for the aggravated assault of Miss Sunshine Wheatley, and based on the evidence here, bring back a verdict of guilty of aggravated assault. Thank you.
Mr. Lee.
Morning, and again, thank you for being here today. This story does involve two people who have a relationship with each other. They know each other. This isn't the first time they met before today. It wasn't the first time they had met, if they had met on that day. So what's interesting is the prosecutor starts by telling you a story about a fight that happened at the store. Interestingly enough, that's not the story the complainant witness told. Okay, she said it happened somewhere. The way the fight went down, you will hear, is different from the way the boyfriend tells it to the way she tells it, okay? And lastly, he talks about protecting or defending. The story they tell describes defense of others, okay? I've included that instruction in the jury instructions for you so that you could consider that, because that's the story they tell, is that a woman ran up with a gun to protect the two young ladies who were now involved in a fight with this man, okay? That's the story they tell. Interestingly enough, my client wasn't there. I'll say that again. My client wasn't even there. I have witnesses who are going to come and tell you where she was, what she was doing. She wasn't there. Okay. Now, sometimes our mind plays tricks on us. I'm not saying somebody's bad or evil or what, they just made a mistake. You ever been out of town or somewhere and you thought you saw somebody you knew, and then you got close and said, oh, wait a minute, I don't know you. Well, why did our mind do that? Did we want to see that person? Is there something about that person that made us think of somebody? I don't know what all the motivations could be to how this misidentification occurred, but that's all it is, just a misidentification. And I'm going to put somebody on the stand who was also involved in this incident, and we'll tell you the details of the incident and explain to you exactly what happened as well. So you, again, will be in that position where you're going to be getting multiple conflicting stories, and you're going to kind of have to sort it out. Who do I believe? What sounds most reasonable or likely? And I think that some of the inconsistencies that you're going to hear over and over again from the prosecution's side are going to add up to a not guilty verdict for you. You'll understand that as you hear the evidence. So again, thank you for being here today. Appreciate it.
Thank you. You can call your first witness, Mr. Bartlett.
Thank you, Your Honor. The people call Miss Sunshine.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
You can have a seat there, ma'am. So there's a microphone that is in front of you, and behind you is my court reporter. Her job is to take down everything stated in the court. So we need your responses to be loud and clear, okay?
Yes, ma'am.
Also, no head nods or shakes and mm-hms and uh-hs, because we can't understand that when she has to type that into the record, okay?
Yes, ma'am.
If there's an objection by either of the attorneys, you would immediately stop your response if you're giving a response at that time. I'll make a ruling on that objection, and then I will let you know if you can give us that answer or not, okay?
Yes, ma'am.
State your first and last name and spell both of them.
Sunshine Wheatley, SUNSHINE WHEATLEY.
You can proceed, counsel.
Good afternoon, Ms. Wheatley.
Yes,
Ms. Wheatley, do you know an individual named Lorandy Lemus?
sir.
And how do you know Miss Lemus?
From the neighborhood growing up.
Oh, how long would you say you've known Miss Lemus?
About like almost 20 years.
And do you see Miss Lemus anywhere here in the courtroom today?
Yes, sir.
And can you identify where she's sitting in an article of clothing she's wearing?
My black and red shirt. I mean, black and white, I'm sorry.
And where is she sitting?
To my left.
Please let the record reflect the witness has identified the defendant.
Any objection to identification?
No objection.
Identification is noted.
All right, so Ms. Wheatley, I want to take you back to April 19th of 2022. Do you remember that date?
Yes, sir.
And why do you remember that date?
Because I was assaulted.
Okay, and did you encounter Miss Lemus on that date?
Yes,
Okay. And was anyone else there with, did you encounter anyone else with Miss Lemus on that date?
yes, sir.
And who else was that?
Her daughter Nevaeh
Uh,
and my cousin Alexis.
okay, and what's Nevaeh's full name?
Melina.
Oh, all right. Okay. So you stated you were assaulted on that date. Where were you when you were assaulted?
I was at a Mexican store in Larch. US 27.
Can you speak up, please?
On Larch in US 27.
Okay. Now in okay. And was anyone else with you at the store there that day?
Yes,
Okay, and who was there with you? that
my
day?
11-year-old son and my boyfriend,
Okay, and what's your boyfriend's name?
Damari Watley.
Okay, and is the name of it the Mexican store?
It's left front that I believe.
Okay, is that located in the city of Lansing
Yes, sir.
in Ingham County?
Yes, sir.
Okay. So when you were at that store, did you encounter Miss Lemus at that time?
Yes.
Okay, and how did that encounter begin?
When I came out leaving the Mexican store, they were outside waiting for me.
Okay, and when you say they, can you just,
Randy and Nevaeh and Alexis.
okay. And so you come out of the store and they're waiting for you. What happens then?
I didn't see them at first. I had got in my car and Nevaeh came to my window, knocked on my window and said, "What's up?" And I opened the door and I asked Randy to get your daughter. And that's when she started fighting me.
No,
And
hold on, pause right there for a second. So you said Nevaeh is at your car, your
Yes.
car door, correct? And when you say she started fighting you, can you explain what
where
happened?
she grabbed my hair first, and then that's when everybody else came after. And we got pulled to the ground.
And were you pulled to the ground by your hair?
Yes.
Okay. And then when you say everyone else came after, who else?
Alexis and Lorraine.
Okay. Was Lorandi there at the initial time of the assault?
Yes.
Okay. So you're pulled to the ground, then what happens?
We're fighting and all I hear is somebody say, well, Randy, I heard her say, I know her voice, "I have a gun." And I was on the ground and I couldn't see because I'm getting trampled on. And my boyfriend's trying to protect me.
Okay, so just if I can pause you right there for just a second. You said you couldn't see because you were being trampled on. Can you explain that just a little more, please?
Punched, my hair pulled. They were all on me.
Okay, and what position are you in at this point when?
I'm on the ground.
And when you say you're on the ground,
Yeah, they're all on top of me.
are your eyes which way are your eyes facing?
Down.
Okay. Okay, so and when you say they are doing this, was Miss Lorandi involved in the assault at this time or?
Yes.
Okay. So you stated your boyfriend tried to protect. Can you explain just a little bit if you know how that happened?
When I heard I got a gun, he just jumped over me and they were trying to hit me, but they were hitting him too, and they also hit my hand, which I thought was right.
So when this all started, where was your boyfriend at this time?
He had got out as soon as they started jumping.
Okay, and then when did he step in and try to defend you?
As soon as he was trying to told him to get back to try to get him off me. And then when we heard the gun, and I believe, obviously they're coming toward me, he jumps over me. So he was on top of me trying to protect me, but they were still hitting me, kicking me.
Okay. And to the best of your knowledge, I realize you said your eyes were down, but to the best of your knowledge, did you ever see or hear your boyfriend strike anyone at this time?
No, he didn't.
All right. So you said Miss Lemus was there, and what did you hear her say at this point?
I got a gun.
Okay.
She was telling my boyfriend, "Don't touch them, don't touch them. Don't help me," basically.
Okay. And so what happened after you heard that?
I just felt myself get hit, my hand break.
And can you describe what you felt hit you?
It was a metal object.
Okay. And to the best of your knowledge, when this, obviously based on that, to the best of your knowledge, when this started, did anyone else have any sort of metal object with them at that time?
No.
Okay. And so just again for the jury, how long have you known Ms. Lemus?
For about 20 years.
Okay, and how, just if you could ballpark, how many interactions a week do you have with Ms. Lemus?
We live in the same side of town. We see each other at the store, stores around Willow.
Okay. And so would you say you're fairly familiar with her voice?
Yes.
Okay. And so when this metal, going back to the assault, when this metal object struck you, can you describe what you heard at that time?
I felt my hand, well, my bone pop in my hand. And when I looked at my hand, it was disfigured.
Okay. 1 second, Your Honor. And so what happened after your hand was hit with the metal object?
Objection, Your Honor. A prosecutor keeps referring to a metal object. The defendant has said she could not see what was being used by anybody. So how do we know?
So it's assumed fact it's not in evidence. Is that your objection? Do you want to respond?
Your Honor, the witness has already testified that she felt a metal object hit her hand.
She testified that she felt a metal object in her hand. Maybe you might want to cross-examine her on that. So the objection's overruled.
So again, after your hand was hit with this metal object, what happened after that?
There was a lot of people around and people were yelling, "We're gonna call the police." And so everybody kind of, got in their cars and I went straight and called 911 and to the hospital.
Okay. So about, based on your recollection, if you can, estimate how long did this assault last?
It was quick. I'd say probably 5 minutes.
Okay. And what you kind of said briefly, but what did you do after the Miss Lemus and her daughter, Miss Mejia, left?
I went straight to call 911.
Okay. And where did you go after you called 911?
I went to my aunt's house.
Okay. And where is your aunt's house located?
My aunt is located around the corner from the Mexican store.
Okay.
On 7th Park, the park around the corner. She
Do
lives
you-
on Vance.
Do you recall what address that is specifically?
My aunt's address is 810 Vance.
Okay. And did you meet, when did you talk to the police about this incident?
I talked to the police at my sister's house.
Okay. And what is your sister's address?
1324 Robertson.
Okay. So the police didn't respond. Is it fair to say that the police didn't respond immediately to this?
No, I told them I was going to meet them at my sister's.
Okay. Now after this assault, did you ever receive any medical attention for your hand?
Yes, sir.
And where did you go to receive that medical attention?
Katranji's Hand Center.
Okay. And what did you learn had happened to your hand during this assault?
It was broken. I had pins in my finger and I still can't use it properly to this day.
Okay. All right, I am going to show you what has been marked as People's Proposed Exhibit 1. Permission to approach here.
Okay.
Yeah. I just would like you to take a look at, there's 2 pictures there. If you can just take a look at those for a second and look up when you're done. Yep, there's 2 pictures there. Do you recognize those pictures?
Yes, sir.
And how do you recognize them?
That's my hand.
Okay. And is that a fair and accurate representation of what your hand looked like on that day?
Yes, it looked worse later on as it bruised.
Okay. And who took these photographs?
The officer.
Okay, and about how long after the incident was that?
35, 40 minutes, that's how long it took them to respond.
Okay. At this time, Your Honor, people would move for admittance of people's proposed exhibit 1.
Any objections to People's One?
No objection.
People's Exhibit 1 is admitted.
All right, and now if you could, just for, so this, can you, and permission to approach again, Your Honor?
Yes.
Can you circle on those pictures where you were hit with the metal object? Yep. Is it working?
A little bit.
Here, right, permission to approach again here.
Yes.
And this one.
I think it's just sticking.
No. Oh, permission to approach.
Yes.
Then I would ask permission to publish People's Exhibit 1 to the jury, Your Honor.
Yes.
And then no further questions at this time, Your Honor.
Prosecutor.
Ms. Wheatley, you testified just now that the event happened at the Mexican store, La Sarita, I think is the name of it. But in your original statement to the police, did you say something different?
No, sir. I told them they had followed me after that to my aunt's house because they did.
Okay. Your Honor, I'd like to share this video of Ms. Wheatley's testimony to the police. I'm not sure if I'm.
Is this being offered as an exhibit or for impeachment?
For impeachment.
Okay. I have to give you co-host. So just a minute.
Share some.
Yeah, make sure you click share sound in the corner when you. Mr. Brodowitz, do you mind grabbing that exhibit, please? You can bring it up here. Thank you.
So this is you, yeah?
Yes.
On the day when you made the
Yes.
police report, okay. And so the police officer is asking you about the event.
In my car.
Oh,
It's
in your
my
car?
yeah.
At Family Dollar or where?
No, I was
where
by
at?
my aunt's house over on the north end by the behind US 27. There's a park right there and stuff. My aunt lives right there.
Behind US 27.
Yeah.
Like,
You know McDonald's is? Yeah.
mm-hmm.
Yeah, she, I don't know her exact address. That's what I'm saying. Telling you, like,
It's on
in my Family Dollar about a month ago. And pulled a knife and tried.
Oh, that's because of this, I guess. I'm so sorry. Just trying to increase the volume on things, so. Okay, so the police officer is asking, what happened? Where did it happen? How did it all go down?
You have to replay that. 'Cause we
Yeah,
just
so
said.
they see me open my door again like they did at Family Dollar.
Where were you at?
In my car.
Oh,
It's
in your
my
car.
yeah.
At Family Dollar or where?
No, I was
where
by
at?
my aunt's house over on the north end by the behind US 27. There's a park right there and stuff. My aunt lives right there.
Behind US 27.
Yeah.
Like,
you know where
That's you
McDonald's is?
saying
Yeah.
to the police officer, I was at the park on 7th Avenue when they approached my door and that's where this
I
fight
said
happened.
US 27.
You said you were at the 7th Avenue.
I
Park,
was
right?
around at my aunt's house. That's where I came from.
Mhm.
Play it one more time, please.
At Family Dollar about a month ago and pulled a knife and tried to stab me. And the police didn't take him to jail. They broke my windows and everything. Police didn't take him to jail. I've been. That's what I'm saying, telling you guys. Yeah, so they see me open my door again like they did at Family Dollar
Where were you at?
in my car. I
Oh,
was
in your
my
car.
yeah.
At Family Dollar or where?
No, I
where
was
at?
by my aunt's house over on the north end by the behind US 27. There's a park right there and stuff. My aunt lives right there.
Behind US 27.
So that's you saying you were at the park when they
Yes, we were.
opened your door.
I was at my aunt's. I had went to the store. He was asking me where
But
I
you
was.
told the police officer that you were
I
at
never
the
said
park
the
when they
address.
opened it.
I
You
said
just
US
said it on the
27.
video.
I just said US 27.
So the store is about 2 miles away from your
No,
aunt's house, right?
right around the corner.
It's right around the corner.
Right around the corner.
Okay. My Google Maps tell me differently, but I'll take your word for it, I guess. Okay. So how long did this whole entire altercation last?
About 5 minutes.
About 5 minutes. It'd be interesting to you to find out that you had told the police officer something different when you reported it. You said something more along the lines of 30 seconds, 60 seconds.
I didn't have a stopwatch, so I couldn't tell you.
So the
I just know
answer is
we
you don't
didn't.
really know how long it took, right?
I really don't. I'm just, that's an
Gotcha.
honest guess.
And so you had also testified that it was your position during this whole thing that your head was down and you couldn't really see what was happening, right?
I can, just people walking back and, or running back and forth and everybody just all over the place.
Gotcha.
I'm
And-
trying to protect myself.
And you said that the way that you knew it was LaRandy was you heard her voice and you recognized her voice.
Yes, sir.
So your identification is completely based on your voice.
Yes, sir.
Gotcha. And did your boyfriend share with you the fact that a detective had contacted him to get his side of the story?
Yes.
Did he tell you what he told the detective?
Yes. Well, not really, but they talked on their own.
So your boyfriend didn't share with you what he
He
said?
just
to
said
the
I told the truth.
Gotcha. Now, in that little clip, you talk about somebody walking up to your car and opening the door. But here this morning, you said they were waiting for me. They were all waiting for me in the parking lot. So were they all waiting for you?
Yes, sir.
I see.
They were first in the car, but they had tinted windows, so I couldn't see that it was them.
And what kind of car were they
A
driving?
Grand Traverse.
A Grand Traverse?
Yeah.
What color?
It's like a dark blue, almost blackish color.
And so it is your testimony that after your boyfriend engaged the two girls, that's when somebody else came running up, right?
Yes.
Gotcha. And so you didn't actually see anything hit your hand, you just felt something hit your hand,
No,
right?
I felt it.
Yep, okay. No further questions, Your Honor.
Redirect.
Just briefly, Ron. So just to clarify a little bit, Ms. Wheatley. So you said this assault happened, again, I cannot remember the name of the store, I apologize, but what you referred to as the Mexican store on US 27, correct?
Yes.
Okay, and then where did you go after the assault had ended?
I went to my aunt's back around the corner.
Okay.
Tell my mom and my aunt what happened because I was going to the store for that.
Okay, and then where did you go after, how long were you at your aunt's house after that?
Just enough to call the police and meet them at my sister's because my aunt and them had a potluck to go to.
Okay, and is that the video that we saw, is that, was that taken at your sister's?
Yes, sir.
Okay. No further questions, Your Honor.
Okay, ma'am, there is a sequestration order, so that means you are not allowed to discuss any portions of your testimony with any other witnesses. Do you understand that?
Yes, ma'am.
Okay, you may be excused. You can call your next witness. Oh, I'm
Yes.
sorry. Give me just a moment. I forgot to ask the jury if they had any questions. Any questions from the jury for this witness? Okay, thank you. Now you may be excused.
Thank you, Your Honor. At this time, the people would call Mr. Damari Watt.
Mr. Broadwood, do you have someone to assist you to get the witnesses correct?
He is, not officially, but he is here.
Okay, where's your witness?
He's coming first.
Turn your phone needs to be off. Okay, thank you, sir. You're gonna come right here, and when you get there, stop and raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You can have a seat there. There's a microphone in front of you. Behind you is my court reporter. Her job is to take down everything being stated in the courtroom, so I need your responses to be loud and clear and verbal, okay? So yes or no, no mhm, uh-huhs, or head nods and head shakes, because we can't understand that when she tries to write it into a record, okay?
Okay.
If you don't understand the question, you can ask or let us know you don't understand the question. If there's an objection by either of the attorneys, you would stop speaking immediately. I'll make a ruling on that objection, and then I'll let you know if you can get that response or not, okay?
Okay.
Please state your first and last name and spell both.
Mari Watley, first name Bemarie, last name Whatly.
Thank you. You can proceed, counsel.
Thank you, Your Honor. Good afternoon, Mr. Watt.
Hi.
Mr. Watley, do you know an individual named Larandy Lemus?
Yeah,
Okay, and how do you know Miss Lemus?
I know her because of the current situation that's going on.
Okay. Had you ever met Miss Lemus before this incident took place?
No.
Okay. Are you familiar with what Miss Lemus looks like?
Yes.
And do you see Miss Lemus anywhere here in the courtroom today?
Yes, I do.
And can you please identify where she's sitting in an article of clothing she's wearing?
To your right, in the black dress shirt with white straight.
Please let the record reflect the witness has identified the defendant.
Any objection to identification?
No objection, Your Honor.
Identification is noted.
All right, thank you. Mr. Watley, I want to take you back to April 19th, 2022. Do you remember that date?
Yes,
And why do you remember that date?
I remember the day because that was the day of altercation.
Okay, when you say the altercation, what do you mean specifically?
I mean, when we went to the Mexican store, or I don't know the name of it, sorry about it. Wasn't trying to be racist, but we went to the store and that's when me and my girlfriend had ran across the means.
Okay. And when you say your girlfriend, who is your girlfriend?
Sunshine Wheatley.
Okay. And were you with Miss Sunshine Wheatley on that date?
Yes.
Okay. So you stated that you were at the what you referred to as the Mexican store. Do you recall roughly what the location of that store is?
Old 27.
Okay.
Right across from it's a restaurant across the street. This Nicholson.
Okay. And you stated you encountered Miss Lemus on that date, correct?
Yes.
Where did you encounter Miss Lemus?
Well, we encountered her and her daughter after coming out of this.
Okay. So you met her, and when you say her daughter, do you know her daughter's name?
Nevaeh.
Okay. And was there anyone else there with them at that time?
Can't recall.
Okay. All right. And so this the place you referred to as the Mexican store, that's located in the city of Lansing, right?
Yes.
And that would be in Ingham County?
I don't know what county that would be in. I think it's Ingham or Clinton around that area.
Okay.
I think it's Ingham, right?
So when you encountered Miss Lemus on that day, how did that begin?
Okay, so we went inside the store and purchased food to cook. And as leaving, we didn't even know that they had followed us there or how they would know we were there. But when we were coming out to the store, walking to the car, her and her daughter had pulled up and like right up on us. And her daughter and her had got out the car or whatever and tried to start an altercation with my brother.
Okay, and when you say they tried to start an altercation, what were they doing?
Well, her daughter had walked up to the car and tried opening the door and yelling and talking or whatever about who knows what they were arguing about.
Okay, so prior to this this incident, were you and Miss Wheatley, where were you and Miss Wheatley when this began?
I don't understand.
So, okay, let me just clarify a little bit. Were you outside, were you out in the open, or were you inside your vehicle?
We was inside the vehicle,
Okay,
like trying to get inside the vehicle, kind of like inside, outside the vehicle.
Okay.
Like we were on our way from the store to the car.
okay, and so you stated that Miss Lemus's daughter came up and attempted to open the car door, correct?
Yes.
Okay, and what happened at that point?
Well, she opened the car door or whatever and said a few words, and then her and her mother started attacking her. Physically.
And when you say attacking, can you describe a little bit how that occurred? Like what happened when you say attack?
Grabbing her, punching on her, and stuff like that.
Okay, where specifically did
she was on the passenger side? I was the one to the driver.
Who was on the passenger side?
Sunshine.
Okay, and where specifically was Sunshine grabbed by them?
Clothes, like, so she's sitting in the chair in the passenger seat. So grabbing like her sweater and hair.
Okay. And so then what happened after the attack on Miss Wheatley began?
Okay, so as her and her mother was attacking her, I had got out the car and I was coming around to break it up. But in the midst of that, Randy had said that her daughter was underage, not to touch her.
Okay. And did Miss Lima say anything else at this time?
She also stated that she had her firearm.
Okay. And at this point, where are you standing in relation to the assault when that's said?
I'm right there in it.
Okay. And when you say in it, are you hitting anybody? Are you swinging at anybody?
No, I'm shielding my girlfriend from all the punches and.
Okay. And so you said that Miss Lima said she had her firearm. Did you ever see a firearm?
Yes.
Okay. And can you just briefly describe that for the court?
It was a handgun and it was black.
Okay. And then, so what happened after you heard Miss Lima say she had a handgun?
I just kept shooting and just was telling her to get her daughter and to stop, like for her to stop, everything to stop.
Okay. And did you ever see Miss Lima swing that firearm?
I don't recall. I was too busy shooting. I was like these, looking down.
Please let the record reflect the witness has testified that he was, I think, sort of hunched over with his arms spread out and angled to his sides. I believe as he was showing, attempting to shield someone or something.
Somebody.
And so what happened as you're trying to, who were you trying to protect at that point?
Just my girlfriend.
Okay. And so as you're protecting your girl, what happened as you were trying to protect your girlfriend at this point?
Pretty much they just kept trying to hit her, hurt her, I guess. Pretty much I was getting hit too a little bit, but I'm all right. It's mostly her. They had also went to the ground at some point, like it was like a big old tussle. And I think that's when, I don't know, stepped on or got hit, but I know that her finger got broken in the process.
Okay, and when you say her finger, who do you?
My girlfriend's finger.
Okay, and that would be Miss Wheatley? Yes. Okay. And so how did this assault end?
She told her daughter, let's go. They all stopped attacking her and they all went in their car and left, but they didn't really leave. They got in the car and pulled off because when I had helped my girl off the ground, when we got back in the car, we had her auntie stayed around the corner and we went over there and they had followed us.
Okay. And what type of vehicle did you see Miss Lemus and her daughter arrive in?
Traverse, I think, a Chevy.
And what color was it?
Like a midnight blue.
Okay. And what did you and Miss Wheatley do after the assault ended?
We went around the corner to our auntie's house.
Okay, and what happened when you got there?
They had followed us there, and while we were there, they were talking, talking shit and talking trash, and she had waved her, showed her firearm.
And did anyone ever notify the police at any point?
I think she called the police.
And when you say she, who do you
My
mean?
girlfriend.
Okay, and that would be Miss Wheatley, correct? Okay. And what happened, where is, again, just, I believe you may have said it, but where is Miss Wheatley's aunt's house in relation to the store?
Literally around the corner, kind of like, think like Geyer, Park is in the area, so it's in the same area, so like a Bench Street.
No further questions at this time, Your Honor.
Cross-examination.
Being here. So it was your testimony that this incident happened at the Mexican store, as it's referred to.
Yeah.
And you said you saw Lorandi and Nevaeh. Did you see anybody else there?
Not that I recall.
Okay. If I was to refresh your memory with a statement you gave to the police, would that help you recall things differently, perhaps?
Sure.
Okay. Just highlighted portion there in that second paragraph too. So was there anybody else there per your testimony? Or was it just Lorandi and Nevaeh?
Third person was there.
Who was this third person?
Alexis.
Do you know who Alexis is? Have you met her before?
Yes, I know.
Okay. So you met Alexis, she was there, but you just forgot that she was there today.
Yeah, it's been a while since the incident.
Right, sure. And I'm sorry, maybe I missed it. When you said the fight started, who was the fight between when it first started?
What do you mean?
Who was fighting when the fight first started?
Her, the mother and the daughter, and then that's how it started.
Would it refresh your memory, perhaps, if I let you read the next paragraph in that statement that you gave to the detective?
Sure.
This is the statement you gave to the detective.
Can you speak up so we can hear it on the record? Whatever you're saying has to be.
Oh,
picked
I'm
up.
sorry. I'm asking him to go ahead and read the paragraph that's highlighted so it can refresh his memory. Good.
Yeah.
So having read that statement, do you want to change your story about how the fight started, or?
No, because when I explained to the officer my statement, she probably got it. She was jotting down notes, but my statement is her and her daughter had my brother.
I see. Okay. Your Honor, can I publish this for the jury to see this at all? No? Okay. Gotcha. Okay. So how long did this whole altercation start? Or how long did this whole altercation last, rather? I'm sorry.
At the store?
Yeah.
2 minutes, like
A few minutes.
2 minutes as far as the altercation goes.
Right, okay. And then you testified that that you guys were on your way to the car when the fight started. So did the fight start inside or outside the car?
Outside.
Outside the car, gotcha. And then you said you had never met Lorandi before that day. So that day you saw her, identified her, and remember her today from that day. As this,
One second. If you could just say yes or no, they're
Oh,
recording.
sorry,
everything, so.
yes.
okay. So as this incident is going down in a very short time period, was your heart racing? Was your adrenaline pumping?
Yes.
Had you been consuming any alcohol that day?
No.
No. Any drugs of any kind?
No.
So heart racing, blood pumping, everything going down. How long did you say that you were able to get a look at Miss Lemus?
The whole time I was there.
The whole time you were there? She was there the whole time you were there?
Yes.
Okay, because they came together in a blue Grand Traverse.
Yes, they did.
And as you got involved in the incident, what did you do? How did you protect Miss Lemus?
Sure, that's it.
So how were you able to get in between the people that she was fighting with and her? I mean, if I'm engaged in combat with Jeff and you're gonna shield Jeff from me, you gotta get between me and Jeff, right?
It's not that hard, man.
Okay, so you were able to move the girls around pretty easily.
I didn't move nobody. I just, I mean, if I moved anybody, it wasn't me.
And it was your testimony that you did not see anybody swing a gun, right? That's what you just testified to, right?
Is that a yes?
Yes, I'm sorry. I'm sorry.
And you said that you believe that Miss Wheatley's finger got hurt when she fell to the ground. Is that correct?
I think I got hurt throughout the process. Yeah.
No further questions.
Redirect.
Just read.
So just a couple of quick things. During this altercation, just to clarify, you never hit anyone, correct?
No, I didn't put my hands on anybody.
Okay. And now you also stated previously that you never saw Miss Lemus swing the firearm, correct? If you would seeing the statement you gave to the police officer refresh your recollection?
Sure.
Okay.
He didn't say he didn't remember. How are we refreshing his recollection?
Okay, let me rephrase it.
Okay.
Would it be possible? Are you 100% on that, or are you that you did not see her swing the firearm?
I said at first I didn't recall. She said she had a firearm, not to touch her under the belt, but she showed it, and then I was shielding my girlfriend as far as her pulling it out and swinging it. I don't really recall because there's a lot of action going on.
Okay. And with that, would it refresh, if you saw the statement you gave to police, would it refresh your recollection?
Yeah.
At this point? No. Permission to approach your Honor.
Yes.
If you could just read the small paragraph right there. This one right here, and then look up when you're done. All right. So did that refresh your recollection, Mr. Watley?
Yes.
Okay, so at the time of this incident, did you ever see Miss Lemus swing the firearm?
No.
I'm sorry, I didn't hear his response.
I said at the time of this altercation, did you ever see Miss Lemus swing the firearm at anybody?
No.
Okay. No further questions, Your Honor.
Thank you. Any questions from the jury? I have a question, just for clarification. It actually was my question before we went through that exchange. But your statement on direct, which is when he questioned you the first time, you stated that you don't know if your girlfriend was stepped on or got hit, but her finger got broke. So you didn't see how it got broken, did you? You just know it got broken during the incident?
Yeah.
Okay, thank you. Any questions based on that question?
Nothing from the people, Your Honor.
There's a sequestration order. That means, sir, that you cannot discuss any portions of your testimony with any other witness, okay?
Okay.
You may be excused. You have another witness?
Nothing for the people's case in chief, Your Honor. There's possibility of one rebuttal witness, Your Honor. But at this time, the people would rest their case in chief.
Okay, so we ordered luncheon for you, and since it's not here yet, we're just gonna keep going. So you can call your witness if you're gonna call witnesses at this time.
Thank you, Your Honor. Your Honor, the defense will make a motion for a directed verdict.
Okay, so let's excuse the jury. Be excused.
Allegation is that the actions of Ms. Lemus created an aggravated injury to the complaining witness. However, the complaining witness has already testified that at best, she could identify that Ms. Lemus was there by voice, but she never saw Ms. Lemus with the gun, never saw Ms. Lemus swing a gun. And the boyfriend, I'm sorry, what's his name? Mr. Watkins. He came in.
Watley.
Watley, I'm sorry.
It's Wheatley and Watley. So
Wheatley and
they're
Watley.
close.
Yeah, yes, they are. So Mr. Watley came in and testified that he did see LaRandy there. He testified that he did see a gun. However, he also testified that he never saw anybody swing a gun. He doesn't know how her finger got broke. At some point in this incident, it got broke. It could have been when she fell down. Therefore, there's nothing on the record that is definitive in any way that says that Ms. Lemus swung a pistol, striking the victim in the hand and causing a broken tooth. There's no testimony on the record that states that at all.
Your response?
Yes, thank you, Your Honor. When viewed in light to the non-moving party, as this should be, I believe that we have presented a question of fact here. Ms. Lemus testified that while she did not hear anything, she could identify from years of experience. Ms. Lemus by voice heard Ms. Lemus state that
She didn't see anything. You said why she didn't hear anything.
So, yes, while she did not
Okay.
see anything, she did hear Ms. Lemus's voice stating she had a handgun. Ms. Wheatley also testified that when this assault occurred, nobody had any metallic objects in their hand at the time. She then testified that a metallic object consistent of a handgun struck her hand, causing it to break. We also have testimony from Mr. Whatley that he saw Ms. Lemus at this altercation, saw her with a firearm. And so I believe we have presented enough evidence, Your Honor, to show to the jury, if not circumstantially, that it was the firearm that hit Ms. Wheatley's hand and caused it to break, Your Honor.
Any argument?
I think that the firearm striking the finger is speculative. That's what they think happened. They don't know. They have nobody that can say, I saw this woman swing her gun and hit her. Even the complaining witness, or even, I'm sorry, Mr. Wiley, who is the primary person who had visual on the incident, cannot say that that's what happened. Therefore, Your Honor, we move for a directed verdict.
Thank you. Mr. Lee, it sounds like you already have your closing statement. And so I believe that just based on the testimony we have, which I don't dispute there's some need to connect some dots here, but that's what your argument is for. I think that I'm going to reserve decision under Michigan Court Rule 6.419B. I believe that there's enough to let the jury make a determination as to any issues of fact at this point. And so I'm going to reserve decision, and we'll continue to either closing statements if that's what you want to do, or you can have time to discuss with your client if you want to continue with calling witnesses, or if you believe that's necessary. Okay. Thank you. Any additional matters before we see if our lunch is here?
Nothing from the people, Your Honor.
Okay, we'll take a brief recess.